Okay, sir. So we are going live now on YouTube. Good afternoon, everyone. Good afternoon, sir. This is Devashish Kumar Panda, co-founder of Lex Cognoscenti. So before introducing our today's guest, I would like to inform you all about my venture, about our venture, that is Lex Cognoscenti, and what is its main purpose. Lex Cognoscenti is a virtual platform, and the very basic purpose of this virtual platform is to disseminate legal knowledge among young legal professionals and law students. We are aiming at unearthing lesser known facts, and we are trying to connect some of the best legal minds of this country with young law students. And with that very purpose, keeping that in mind, we are doing this particular Rendezvous series, wherein we are calling eminent legal luminaries all across India. And today we have one of those legal luminaries, Mr. Manoj Kumar Mishra, who is who is a distinguished senior advocate, uh, and who is litigating for more than 42 years in the Orissa High Court and appears before the Supreme Court of India and a number of other high courts, National Company Law Tribunal, and various other tribunal and other various forums. He has dealt with multifarious cases which include a wide range of laws, including constitutional law, corporate and company laws, service laws, banking laws, mining laws, etc. And he is the former Orissa State Bar Council member and was a member for almost 20 years. He is also a former member of Disciplinary Committee of Bar Council of India for 5 years from 1997 to 2002. And he was conferred with Professional Excellence Award in 2010 by the then Honorable Governor of Odisha. He has been honored as an eminent lawyer by Sirdi Sai Cultural Mission Odisha by the then Honorable Acting Chief Justice of Orissa High Court. He has also been honored with National Aain Ratna, Utkal Ain Seva Samman, and Utkal Ain Gourav Samman. He has been the counsel for many public sector undertakings like NALCO, SAIL, BCI, and etc., and several other banking institutions like Urban Cooperative Bank, Central Bank of India, UCO Bank, etc. So I, Devashish Kumar Panda from the team of Lex Cognoscenti, would like to welcome you, sir, on board with us for today's discussion with you.
Thank you.
Thank you so much, sir, for gracing our interview session with your humble presence. So, with that, with your due permission, sir, I would like to start the first phase of interview session, and the second phase would be taken up by our co-founder Jyoti Prakash Datta.
Yes, you can start. First of all, I offer my thanks to you and your organization, and also to viewers for inviting me and for witnessing my interview.
Thank you, sir. We are also highly obliged for that. So, sir, now starting with the very basic question that we ask to all of our interviewees, that is regarding your childhood, family background, and schooling. So, if you can tell us something on that.
My father was an engineer who unfortunately died at a very young age of 50 years only, when I was 15 years old, and I was I had appeared in the matriculation exam. And actually, my father had the transferable job. So within we were ready in 12 years. That matriculation was 12 years then. 12 years. Sorry, 11 years and then. So between 11 years, I have read around 12 schools. After my father's death in 1970, after I passed matriculation, one of my cousins was then was an engineer, electrical engineer, Nusant Mishra. He brought us up, all of my brothers, sisters. He kept us in Bhubaneswar, and I first read in one college in Jaspur. He was also posted as engineer at Jaspur. Thereafter, he was transferred to Bhubaneswar. I also was. I got myself admitted in BJP College, and thereafter in '74 I passed out BA from BJP College. Thereafter, we had this. We had a house in Cuttack. So this house was occupied by a tenant. He was not living. My uncle, what Odia we call Piusa, my father's brother-in-law. He was an IS officer. He was a very Bimal Kishore Mishra. He was the additional chief secretary then. He actually made all efforts to see that tenant is out, and we get the possession. Ultimately, he said that he, at his instance, I came to profession. He said that yes, you read law in MS Law College and become a lawyer. Otherwise, when you have got a house in Cuttack, so become a lawyer. So first, the idea of becoming a lawyer came from him only, and thereafter, all my family supports and all that. Otherwise, in my family members, nobody was a lawyer. Neither from father side, nor from mother side, neither from uncle side, not from auntie side. Nobody from any side. I was so that is how my childhood was.
That's quite interesting to know about your childhood and how your uncle played a great role in involving you in law and then forcing you, or I would rather say inspire you to do law and become a lawyer. So
Yes,
now I would like to ask you, yes, sir.
yes. Proceed.
So, sir, then I would like to ask you about your law school life. As you said that you were in Madhusudan Law College. So, how was your alma mater and what was your experience at that time?
During our time, there was a morning session from 7 to 10, 11, 3 hours. Morning session was. I was reading in morning session. There was morning session and evening session. Because so I was admitted into morning session. A morning session, actually, at that point of time, there was a in 75, from 75 77, there are emergency being imposed by the government of India at that point of time. So there are few students, but we have got a lot of students, but few students are really appearing, attending the classes. And some students were really very interested in attending classes and listening to the lectures delivered by our the then senior advocates and some other very renowned teachers who are teaching us in all different subjects. The renowned senior advocates at that point of time were many, including Justice Prasad. Many senior advocates were coming, they are taking part-time classes, and some regular lecturers were also there. And the atmosphere is very good. And we used to listen to the classes, but since but there are also some lapses. Where also sometimes my friend of mine was reading in Revensa College. He was reading in English. We were reading English MA. So I was frequently, by missing class, I was frequently going and sitting in his class. That was also morning session in his class. So that way, I was missing many classes. So probably I was not very serious in becoming a lawyer also at that point of time. Anyhow, that was my. But anyhow, we had a good relationship. We were good friends, and amongst our friends, we have got Justice Pradeep Mahanti. Now, who was our judge of our High Court. Then he became Justice of Chhattisgarh High Court. Jharkhand High Court. Then he is the judicial member of National Lok Ayukt. He is a very close friend of mine. We are of same height and same figure, I think. And then Justice L. Mahapatra, he was also my classmate. He was classmate since BJP College. BJP College was reading science. I was reading arts. So in BJP College there are two separate blocks, arts and science. He was reading in science, but we were traveling in the same college bus. Thereafter, Yasavant Das, renowned senior advocate of Supreme Court as well, and many persons, one Jivanandan Das, many persons are there who have become lawyers subsequently. But around 4 to 5 persons, they remained as lawyers. Rest of them they left the practice. So that was my college days.
That's quite interesting to know from you that how was your law school days and how you used to sometimes bunk your class and sit with your friend in his college and classroom. So that is quite interesting to know. So
That was happening
as
in
you
BJP College also. That was happening in BJP College also. BJP College also, I hardly used to attend the classes. You had a chai adda in front of the college. So we 3 to 4 friends we used to go and at chai adda there. And, so
these
my mother
memories
used to
stay with us that how much we
That's
have
why
enjoyed our law school life.
my mother used to say when she was early, she used to say that because you have not devoted much attention to your studies during your school and college days, the God has punished you to read all the time for the rest of your life.
But then that is uh, we can say that that is quite a lucky thing that you are in this profession and we get inspired from you being a senior advocate in Orissa High Court. So that's quite interesting. But as you said that you were sometimes attending classes in Madhusudan Law College. So I would
Yes.
like to know that what all subjects fascinated you being a law student then.
That point of time actually it facilitated me the criminal law as well as Hindu law. I mean, civil law, criminal law, civil law. Both the laws were very fascinating. I was very fascinated by these two laws, and other aspects are there, but these two aspects are really. I was very interested in these two, civil and criminal laws.
Indeed, sir. Even that those are conventional laws, so people tend
Conventional
to
law.
get fascinated by them. Uh, Now, as we have discussed about your childhood and then about your law school, I would like to know that how were your initial days at the bar?
Uh, Initial days at the bar, I'll tell you. Uh, First, I'll tell about how my family inspired me to become lawyer. Besides my uncle, my brother, cousin, who was our mentor, he's no more. His mentor. He said that since you are joining law practice, you are reading law, so make the family proud, be above your just go ahead your brothers are good students. My younger brother is a very famous doctor in Bhubaneswar. Dr. Manoj Mishra must have been seeing him in all these channels in this year. He's my younger brother, and our elder brother is a chemical engineer. He retired as DGM in State Financial Corporation. So he said that since we thought that because you are not reading well, we thought that you will not be able to do anything in your life. My brother said, and my mother also said that we thought that you will not be able to do anything in your life. But prove us that we are wrong. Prove us that you are much ahead of your brothers. The brothers have good students, but even if you are not a good student, but you are in the later part of life you are above them and ahead of them. So that is the reason why my brother, elder brother, he gave his scooter to me, and I used to ride his scooter and going to chamber, going to court, etc. Later on, he also gave his car to me, and I used his car, but all for proposal. I did not misutilize because I didn't have any time to go for any other work. But anyhow, so that is the reason why he said that we, so far as monetary aspect is concerned, don't look for money, give complete devotion to your profession, and be a very good lawyer, so that money part I will take over. I will think about money part. I will take care of your monetary part. Don't think about monetary part. Don't expect any money from your seniors and all that. Do your duty and do your job very sincerely and honestly. That is how I started my practice. After I joined my practice, to get a senior, it was a very difficult task for me, because we had no connection with any legal fraternity in any way. So it took around 6 months to get a senior. To get I was the particular person member. I was the particular person who was practicing tax practice.
Sir, I would like to interrupt you. There is some disturbance in your voice. I
Oh, I
don't.
see.
So if you can repeat the last part of what you have said just now.
So since there was we had no connection with legal fraternity, to get a senior, it was a difficult job for me. So no senior was agreeable to keep me as a junior, because all the seniors are always their chambers are always full. Like now, me in my chamber also, my chamber is full. So somebody comes to me, I said that sorry, my chamber is full, I cannot entertain you. So at that point of time also, I faced the same problem. So I had with much difficulty after 6 months of my passing of the law. My one brother, my cousin sister's husband, my brother-in-law, he said that yes, I know a particular judicial officer. Through him, I'll try to. He contacted his friend judicial officer, and through judicial officer, I could be able to go to Vibhuti Bhushan Rath's chamber. Vibhuti Bhushan Rath was a very brilliant trial court lawyer. His house is the Bhasakosil in front of this Akbar Khan Gudakuyi, and he is a very highly talented civil and criminal lawyer. And he had made a very good reputation on this as a trial court lawyer. So I joined there. So I was there for about 3 years. And his son-in-law is also Jitendra Kumar Mishra, senior advocate. He is also very noted advocate, noted senior advocate. So I stayed there. I learned trial court practice in his chamber. For about 3 years, I learned the trial court practice in his chamber. After 3 years, I always wanted to be a high court lawyer. So I wanted to become, because I was while going to the court, I was finding the house of Bipin Berry Ratho. So and he had lot of cases in High Court. When cause list I see Bibi Ratho, Bibi Ratho, Bibi Ratho. I always desired that, dreamed that I should become his junior. So through our High Court Bar Association librarian, who was very, liking me very much, through him I approached him, and he agreed, and I became his junior. And fortunately, by that time, his main junior had joined the government panel. He had become additional standing counsel with Sarath Kumar Das. He is also senior advocate, but unfortunately, he has died in recent past. So I came to his chamber in 1981 and remained there till 87. For 6 years, I remained in his chamber. And in his chamber, actually, I got all the opportunities of appearing and arguing the cases, because he was such a lawyer. He said that you go and argue the case. You go and argue the case. If you succeed, it will go on your. It will go to your credit. If you lose, then the blame will be on me. Tell the judge that if you succeed, write down your name as arguing counsel in the judgment. If you fail, then write down my name in the judgment. By this process, I got a lot of scope to argue the cases, to read lot of. He has got varieties of civil, criminal, constitutional, all kinds of briefs he had got. So I had the scope to read a lot in his chamber, going through all the briefs, and thereafter also to argue all these cases, most of his cases in High Court, and that is how I became. I was acquainted with the court proceedings and also the argument.
Indeed, sir. You have very well elaborated your journey as a young legal professional under your senior, and how you have worked with them and how they have shaped you to become a better lawyer now. This brings me to ask you another question, that what were the challenges that you have faced in your early days? As you said, one of them that you were not finding uh, being a junior of Bipin Bihari Ratha. So, is there anything else?
No challenges. Very difficult to person without having any legal background, or anybody in the legal field. Very difficult to enter into this profession. Anyhow, by God's grace and my blessings of my seniors, I could be able to do their cases, and they allowed me to argue their cases and prepare their cases, and they took up the entire responsibility. They guided me. Both the seniors guided me, and say that if any doubt is there, just ask me. And they really helped me to build up my practice. The challenge, vast initial challenge, that I was very afraid of appearance in court initial days, because from what happened, I was apprehensive that if I say something, if that is wrong, then I'll be rebuked by the judge. That apprehensive court, that is we say it court fearness. So I had the court fearness for about quite long time. I had the court fearness in High Court. In trial court, I had the scope to appear in some cases. Trial court, I didn't have much court fairness, but when I came to High Court, I had a lot of court fairness, and it took some time to. It is my senior, Mr. Late Dr. Bipin Bhai Ratto. He actually guided me, and he actually helped me to remove that fairness from my mind.
Indeed, sir. Seniors always play a great role in helping us, and then in many other ways. Thereafter, I would also like to ask you that what was the turning point in your legal profession when you started doing cases independently, and if you can share something about your first case in which you have appeared independently.
My first was a very interesting case. That was only after 6 months of my practice. When I joined chamber, 6 months of practice, you must have had Basudev Rath was a very legend music director, Budia music director. His father-in-law was a Bengali. His father-in-law had come to my one of my senior colleagues then in Bhutan, Mr. P.K. Parida, who is unfortunately also no more. He came to him, and that there was his brother had filed a case against him, so for partition, said that please defend me. I don't have any money to engage your senior. And there he said that my sister is also there. There are two brothers and one sister. My sister is also there. I want that don't want that my brother should take all the properties. I mean, a 50% share. My sister must also get something. So that is why. So Mr. Parida asked me to appear for the sister. She appeared for the sister was not a party in the suit. So that you file a petition for impletion of party to be in the trial court to implead yourself as a party and to contest the case. That is how I filed the petition. In course of hearing, at that point of time, when that initially before 1937, this case, it is a typical legal point. Before 1937, we didn't have the codified Hindu law. So practices and customs were the guiding factor. That at that point of time, the women had no right to property, had no right over the property. But there was a system. If there is a partition in the family, then there will be provision for any unmarried daughter's marriage, or any widow is there for her maintenance. Like this, there was a program. That system was being invoked till 1937. In the Women's Right to Property Act came into force 1937, gave limited right to the women, and from 1937, in Hindu Succession 1956, Section 14. 1 and 2, Section 14 gave the absolute, in a particular circumstance, if he is in possession of the property, then she will be in absolute owner of the property, and 14.2 is that limited property. That is a different aspect. Now we are concerned with Section 14 on the Hindu Succession Act. What happened in the particular facts of the case? The sister was a widow. After she during those times, there was a child marriage and all that, so she was a widow from the childhood. So after she became a widow, she had her father had got some property for her sustenance and also built a house for her. So in that particular house she was staying. But since the father had died prior to 1956, this brother filed a suit claiming 50% share, because before 1956, the daughter doesn't have any share. After 56 only, even also the share was that part is different legal aspect. I will not tell you now. But so what happened in that case? Mr. Parida told me that you look out, you try to find out solution how you will be implemented as a party, and how you will establish your share. Then after a lot of research, I found AR 77 Supreme Court 1256. What AR 77 Supreme Court 1256 said, 1265, that if the woman is in possession of her property in exercise of her pre-existing right, then probably section 14(1) will be applicable and she will be the absolute owner. So what is a pre-existing right? Then I made a lot of research, and ultimately I found that right to maintenance, the property given for the maintenance or sustenance of the lady or the woman, it is a pre-existing right. So basing on that, I argued the matter, and I proved that she was in possession. In fact, in a cross-examination, the plaintiff himself admitted that yes, she was in possession of the property. So my suit was declared by that particular property was given to my share. And when that matter was argued, and after argument was over, the learned subordinate judge, then they were called subordinate judge. Now they are called civil judge senior division. Mr. Ghosh, he later on also became a lawyer, and also now he has died. So he called me to the chamber and embraced me. That young boy, you have done it excellently. I didn't know about this law, nor even your plaintiffs. He was a senior officer, senior advocate, senior officer two, senior advocate. Now, coincidentally, his grandson is my junior. So he was the counsel for the plaintiff. He also said, this law, I didn't know it. And you have developed the law so much, God bless you. And you will surely become a very good lawyer in future. And Mr. Ghosh also, the learned officers also embraced me and said that, yes, I bless you. You will certainly become a good lawyer in future. And you'll become a great lawyer in future. And I got the blessings at that point of time after 6 months. That was my first experience. That was my first case. And another case, it was a very interesting case, a little bit humor side. There was a divorce case. So my senior said that you look after the divorce case, because divorce case doesn't need any much technical or legal way. You look after this divorce case. My client was an engineer, was an assistant engineer, and my other side was also another friend of mine. So his client was the lady was a lecturer, government college lecturer, and they had got a 3-year-old very cute son. So what happened when they come to court proceeding? By that time there was no family court. I'm telling about 1978, 79. So there was no family court. So when they used to come to court, so this cute child, he keeps his leg on the lap of the mother, and his head on the lap of the father, like this, like this. So with two friends, said that this was a silly thing. Why they will be? Why not? Let us try for their reconciliation. I mean their reunion. So we has out a plan. I'll tell my client that, I mean, your client was telling very high of you, and she was doing. And similarly, my friend said that yes, I'll also tell these things to my client, so that negativity will be reduced. And what was the reason for quarrel? Cow. Because when my client assistant was in field job, he had got a lot of peons and khalassis to work, and he had a cow. He had a cow, and his father was also a chief engineer. And when he was transferred to Bhubaneswar, the peon and khalassis were not there. So this cow was, how we look after the cow. So wife had a quarrel with him. I said that no, I'll keep the cow. Today I'm at Bhubaneswar. Again I'll be at I will be going to some field job. So the quarrel started like this, because both of them economically sound. I mean, so the ego was there. So because of the ego, the quarrel started, and it ultimately it came to divorce stage. So by this process, when we initially, I told my client that your wife must, she is really missing you, and she is telling very high of you, all these things. Now, why she filed a divorce case? So she had filed divorce case, but anyhow she has got very good views about you. Similarly, my friend also told his client, the lady, that your husband was selling very high of you. Gradually, the negativity. When they after 2-3 sittings, when they came, they started talking each other. Like this process, we thought that gradually probably there is a thaw. So by this process, after 3 to 4 months, ultimately they compromised and divorce case was withdrawn. After about 7 years, when in Bhubaneswar, in a traffic light, when I stopped my car, in a scooter, particular husband and wife, when they had a daughter by them, said that, "Sir, namaskar." Sir, do you remember us? And I said, "Cow case." So by this process, I was able to cow case. I mean, now you are happy, or you are quarreling with each other. No, no, so we are extremely happy, and we have got a daughter also, and then we are now very happily. They ultimately credit goes to you because you people are telling lies. By telling lies, you reunited us. Because there are when they were reunited, automatically they asked that, "Did you tell me?" I didn't tell anything to my lawyer. Naturally, so ultimately by that time they had decided that yes, they will reunite each other and they will have a happy family life. So they thought that to have a good intention, with a good intention, we are doing this. So this is the sir, because of your goodwill, we are reunited. So that is my one of my very interesting experiences in early years of practice.
Both these cases were quite intriguing to know from you, and there were a lot of humor part in them. So that was quite interesting to know from you about both these cases. Apart from that, sir, as you have dealt with so many cases, so I would like to know from you that is there any anecdote which you can share with us regarding any of your cases other than these two? Any courtroom conversation, any conversation between you and opposite party, like the previous cow case only? So, is there any other thing that you can tell us?
No anecdote. I can tell you 2-3 interesting cases. This is not related. Once Justice P.K. Mahanti, my friend, he was also another judge was Justice Pradyumna Mahanti. He was looking young, but my friend was looking old. When they are sitting together in a division bench, Justice Pradyumna Mahanti was against the petitioner. But Justice Pradeep Mahanti was a very liberal judge, so he was in favor of the petitioner. So during that time, lunch there was a lunch break. While we came out from the lunch, came out from the court, this was not my client, some other client. So the client was saying that old man, that old judge is creating all problems. That's it. That young judge is creating all problems. The old judge is good. Old judge was meaning my friend Pradeep Mahanti, quite young person. And the young judge was meaning Justice Pradyumna Mahanti, he was quite old. So that a young then after the court hour is over, I mean after the court resumed, I told the court that yes, both Justice P.K. Mahantis, and this is the view of the client outside the court. Both of them, the entire court laughed and both the entire court and all the lawyers, they laughed to their heart's content. Then I must, then Justice Pradyumna says I must obey my old friend. Old friend means his colleague Justice Pradeep Mahanti, my friend Dipu. So by that way, the client also got the relief, though he was not my client. Some other lawyer was doing his case. But I, after joining at 2:00, I stated it before the court. That is, this is what happened. What is the reaction of the client? And so that was a really funny aspect. And another aspect was the before same Justice Pradyumna Mahanti. We have got our Justice, sorry, Mr. S.K. Naik, senior advocate, who is very fond of food. He is known for food. He was a very, what you say, voracious eater. So what happened in a particular case, 500 cost was imposed on him, on his client, for not filing counter within time. And I said that I paid that. He kept the 500 to me. I said that why unnecessary I'll keep 500. Let us. It is a cost aspect, so we'll utilize it in some other dinner or some snacks and. So thereafter, at a particular weekend in Bhubaneswar Club, along with some friends, we went there, and the bill was around 7,000 some odd. I didn't know. Bill was around 7,000 or not. So anyhow, I paid that amount. Thereafter, next day, when I went to that case came, I told Justice Padinavanti, Speaker Manti, that sir, your cost has become very costly for me. Now how? Now you awarded 500 rupees cost, I had to spend 7,000 rupees as against 500 rupees. Then I narrated the entire story. And all the lawyers sitting in the court laughed. And ultimately, there was in this full court also, this topic was there. In the full court also, Justice Padinavanti raised it, that this is how Manoj had to be penalized because of this. And entire full court also, when full court means all the judges when they sit together for any decision, that is called full court. So full court also, they also laughed. This is also another anecdote. The another anecdote is also related to the same Justice P.K. Manti. Justice Barman Rai was the Chief Justice then. And Justice Padinavanti was sitting along with him. I was arguing on bail petition. I had filed a bail petition in a criminal appeal, murder case. While hearing the bail petition, Justice Barman Rai was very thorough in criminal law. You have got this very short point. Then he asked the government counsel to tell you this is short point. Then we'll allow the application, we'll allow the criminal appeal. Why will be kept waiting for again 10, 15 years more? So, and I couldn't say anything. So they allowed the bail application, criminal appeal. And after accused is acquitted, the order of state goes from the court to the jail. Because from the jail they will be simply go out of the jail. So I told Justice Padinavanti, I mean both the judges, that sir, you have affected my practice by allowing the criminal appeal. Now how? I will not be able to get any fees. There are 3 persons who are accused persons are there. I will not be able to get any fees. Why? Had your lordship granted bail, I would have got some fees. But your lordship allowed the criminal appeal. Now they will be go out of the jail with a laughing face. But why they will come to me and pay fees to me? Both of them laughed and said that, oh, I see. They should have told me. Okay, why even if a client is getting benefit, why shall he tell? Let them get the benefit, and says that okay, Mr. will remember. We'll remember it in future cases. We'll remember it, and that is how Justice Padinavanti also told in another function that you see Manoj told in the court like this, that yes, because of this we are allowed the criminal appeal. He was affected, and some other judges said like yes, he was correct. Because after getting out of the jail, no client will come to him and pay him the fees. So these are the few anecdotes which I have experienced in my year. There are many anecdotes are there, but it will take a lot of time, and I will not be able to also remember all these things.
Indeed, sir. These anecdotes are quite interesting to know and were quite funny also. So I hope this will make our viewers enjoy this particular session more, and they will remember this particular thing about you also. Now, coming to another aspect that I would like you to address is regarding senior advocates. Now, what is the basic difference between being an advocate and then practicing as a senior advocate?
The advocate has got direct link with the clients. So the client is on his head. The burden of client is there. It is on his head. He is answerable to the client. Client used to say, I want this, I want this, I want this, I want this. But he has to convince the client that yes, we are trying to do this, all this. But senior advocate is only arguing counsel. He doesn't have that client's responsibility. Senior advocate will simply prepare the case and argue the case before the court. He doesn't. But he is answerable to himself. Senior advocate is answerable to himself, but not to the client, because he had no direct contact with the clients. So it is the briefing counsel who is responsible and who is answerable to the client. That is basic difference. Basic, very most important difference is this. Otherwise, there is no difference between advocate and senior advocate. Absolutely, there is no difference between that. I mean, so far as court is concerned.
Indeed, sir. That's the very basic and primary difference between practicing as an advocate and the senior advocate, as you rightly pointed out now. Now, as you were saying the anecdotes and you have taken name of quite a number of judges and eminent advocates, I would also like to know any other person who were the dons of the bar or who were eminent members of the bar, and you remember them and you can tell about them so that our generation can know about them particularly.
I always treat my two seniors as dons of bar, and they are really my senior Vibhuti Bhushan Ratha as a trial court lawyer, was a very prestigious and very respectable trial court lawyer. Then my Dr. Bipin Bhai Ratha, he was but Dr. Bipin Bhai Ratha, his son is also a sitting judge of our High Court, Justice Vishwanath Ratha. So he was a totally different kind of man. He was the president of the Bar Association for 4 years. And not only that, he was a freedom fighter also. During student days also he was a freedom fighter. And not only that, he has got many things to his credit. But I'm thinking that he was such a dynamic lawyer that he was really a don of the bar. Thereafter, we found that Mr. Barrister Ranjit Mahanti, Mr. Ranjit, whose son is also Justice Indra Mahanti is also Rajasthan High Court Chief Justice. He was a great lawyer. And Barrister Birendra Mohan Patnaik, former Advocate General, and Justice P.K. Mishra, when he was the counsel, he was the lawyer. He was first he was the junior of Justice R.C. Patnaik. He became later judge of the Orissa High Court and Madras High Court, then Chief Justice of Patna High Court, and now in Goa he became Lokayukt and now retired, and now he has come back. So, and his senior Justice R.C. Patnaik, when he was the lawyer also, Mr. R.K. Mahapatra, Mr. Gangadhar Rath, Mr. Bimal Pal. Bimal Pal used to guide us how to behave in court, how to make submissions in court. While sitting by, if we are sitting by his side, then he will explain. Then Mr. Justice S.C. Mahapatra, then he was when he was advocate, he used to guide us also how to improve your appearance, facial appearance, by dress, your how to build up your library, and how to also to and he always used to tell us that specifically he was liking me, he was liking me like anything. So he used to tell that there is always a void at the top. Fill it up, fill it up. You may find thousands of layers, but ultimately at the top you will find very few layers. Very few lawyers will find at the top. So I would like to see you as the topmost lawyer if I am alive. So and also he was a lot. He used to say how you will build up a library. As per his advice, I started buying at that point of time CLT air and all that. And he said that no, don't buy your digest now or commentaries now, because by the time you start your practice, these things will be old. Outdated, and you will have to buy new ones. So by this process is that so by the time I started practice, about 9 years of juniorship, I had to build up a good library, and I was really happy to see my office that yes, I had built up a good library. So all these senior advocates were very, and these senior advocates, what they are doing, if any problem is there, if you face any problem in court, you are not able to answer anything, or they used to manage it. They used to tell, no, probably my learned friend wants to say this. Probably my learned friend wants to say this. My learned friend, my purpose of saying this is this. And that point, the judges are also accepting it very nice. Nowadays, it is difficult. Now, even if we want, we cannot. Sometimes some judges may say that, oh, are you appearing in this case? Then why are you interfering in this case? So we are not now, we are against our will, we are also not. But some judges are there. Really, they are very good. They also encourage, they also ask, yes, Mr. Mishra, what is this? What is the law on this subject? Can you help us? Can you help the young guy? And outside the court, we help them. Lawyers, if they're facing difficulty inside the court, outside the court, you go read this decision, you read this law and all that, and it will help you. Outside the court, we help them. But during our time, the senior advocates were encouraging the young lawyers like anything. Like if you are argued well, then they will come and appreciate you. They will pat your back. They say, "Oh, you have argued very nicely. I'm really impressed." That gives you lot of encouragement. That inspires you to read further and to become a better lawyer. I also follow the same practice here. Whenever I see a young lawyer arguing well against me or against any other lawyer, I also say that, oh, we are doing very well, keep it up. That needs young lawyers need, because I, having come from totally non-entity background to practice in this court, so I know what the difficulties young lawyers face. There are lawyers who come from very renowned families, and even if their families are not connected, but their families are connected with lawyers and all that. So naturally, they have got a age over other lawyers like us. But we, the lawyers, we have we have to find out the place for ourselves. Thereafter, build the castle. First of all, you'll have to be under the earth. We have to dig the earth. After coming to the earth, then again you have to build the base work. Thereafter, build the castle. So to build the castle, you have to do a lot of labor.
Indeed, sir. We juniors surely appreciate the efforts that you put in for being a senior advocate, and then how you encourage your juniors when you see them arguing very well. So that's quite interesting and encouraging to know for me, and obviously viewers will also agree to that fact. Now, I would like to ask you that as you have practiced for more than 42 years now. So I would like you to address our viewers the very basic pointers regarding drafting, as that is the important thing and that is the essential ingredient for becoming a good lawyer, if we say. So if you can address any pointers on that.
Drafting is very important aspect of advocacy. For drafting a particular case, starting from plain to writ petition or even criminal appeal and all that, and nowadays criminal appeals are drafted very casually, even, and also second appeal. So drafting, you must understand, you must read the brief, understand the subject thoroughly. After understanding the subject, read the law and be thorough about the law on the subject. Thereafter, start drafting. You must place your case. You should not suppress anything, because if you suppress anything, other side will bring it to your to the notice of the court, and ultimately you will be in difficulty. So don't suppress anything. Be very brief, but state all the make short paragraphs, not big paragraphs. Short paragraphs are very important, because big paragraphs, nobody had the patience to read big paragraphs. Short paragraphs, short sentences, because people are have in habit of writing long sentences, and one sentence is a para by itself. So short sentences, short paras, and very effectively, gradually, you'll have to place the case gradually from beginning to end. And first of all, nowadays I find even Supreme Court also and other cases also, the people cite the decisions in their SLP, but in Calcutta also, I am in other place. But I always advise not to refer the decisions in the pleadings, because once nowadays the decisions are always both sides. In a particular fact, if you have cited relied on a particular decision, the other side will go, oh, he is relying on this decision, then I must get the contrary decision. So your drafting will be in such a manner that other side will simply know the fact. You should only state the fact. I am telling about the plaint. In the plaint, you should need not write, you only state the facts. But so far as writ petition is concerned, we'll have to state the law, but state the law in a very lucid manner, very simple manner. You don't say that this has been decided in such and such case, this is decided, all these things. Just what are your grounds, just state it, and keep your, don't put all the cards at a time. I mean, let us suppose you have got 10 grounds. Don't put all the 10 grounds in one while drafting a writ petition. Keep that ground with you. Make 5 or 6 good grounds and file it, because you have always the scope of amending the writ application. If the judge doesn't agree with those grounds, then you can amend the writ application and add those grounds also. But why I say so? After the other side is files counter, then you may get some additional grounds. From the counter also you get additional grounds. I will also tell another instance out of that, how from the counter later on I'll tell, because when but that's when in the counter also you get the grounds. At that point of in a rejoinder, or at that point of you can file amended application and add your grounds. That will be so. Drafting, one must not be in a hurry to the lawyers. After practice about 5-7 years should think of drafting, but prior to that they must follow the seniors drafting. How the senior means not that he is senior, but senior colleagues. You said that, sir, please dictate me. I'll write it down. Please dictate me. Instead of dictating to this, no, please dictate me. I used to do that. I used to ask my senior colleagues, sir, please dictate me. I'll write it down the petitions. Please don't dictate it to the steno, and dictate to me. I'll compensate the steno. I'll pay the money to the steno. My brother was there to pay me whatever. If I asked my brother to give me 500 rupees, my brother out of yes, take 500 rupees without any question. What will you do with that 500 rupees? That is, take 500 rupees from me and do whatever you want. So by this process, I learned drafting. That how the senior colleagues and seniors are doing, and by this I started making my own research after the drafting. Then I thought that if additional ground is required, then I asked my senior colleague, sir, I found this ground, whether it is acceptable to you or not, please look at it. And if it is acceptable, then he adds it, or not acceptable, he says, no, this decision is not applicable in this case, this will go against us, this should not add this ground. Like this, so drafting is very important aspect. But one must learn how to draft from their senior colleagues or the seniors. Senior doesn't have any time to guide the juniors. It's the senior colleagues who guide the juniors. I also got the same benefit from my senior colleagues.
Indeed, sir, you have very well pointed out the nuances of drafting and what we should keep in our mind while drafting a particular thing, and how we can learn that from our seniors. So that was clearly put forth by you. Now the another aspect that is important is handling.
Sorry for it. Before that, in second appeal drafting is very, very difficult, because there is substantial. You will have to show substantial question of law. So what I used to do, my senior had done, that find out the decisions in support of your grounds and write those. I used to write down those decisions in my office, in our office copy, just in the left hand column of the grounds, so that when in future, when the matter is being heard, any lawyer will argue the matter. He will have that these are the decisions basing on which this argument has been, this ground has been taken, and some, because in the second appeal you will have to obtain substantial question of, not mere question of law. There is a lot of difference between question of law and substantial question of law. This is not the forum to say all these things, but it is that. So second appeal drafting is very, very difficult. Plain drafting, second appeal drafting, or written statement drafting in civil suit. As a second appeal drafting, first appeal drafting is very easy. Criminal appeal, I used to take grounds by finding records from after getting the grounds from the records, by reading the evidence, and reading the FIR and other documents. I used to prepare the grounds because that will help me at the time of final argument. Otherwise, for criminal appeal, now lawyers said, "Oh, this is illegal. This is not. It's only illegal, arbitrary. All these things, except using those words, they are not adding any ground because this is at the time of final argument. Let us see what grounds will find it out at that point of time. Because criminal appeals are admitted easily. There is no criminal appeal means criminal appeals are admitted easily. There are statutory appeals. Courts admit it without any specific ground or within substantial ground. Yes, please.
Indeed, sir. So I was asking that there is an aspect of client counseling and handling clients properly, and that is also an important aspect for a lawyer. So if you can tell us something or some pointers on that as to how to handle a client, how to counsel a client properly, and what are the aspects that we should keep in mind.
It's a very difficult aspect. The clients nowadays, previously clients were depending on the lawyers. What lawyers were telling, that's a yes, sir. Even educated clients also. But nowadays, even uneducated clients also, they come and say that yes, I want this relief. I want success only. I do not. So by that point of time, if you say yes, you will surely succeed, then he will be very happy and he will pay you fees. But that is very wrong approach of the lawyer. The lawyer, as there is also bar in professional ethics. We have got a set of professional ethics. You must have read Advocate Act. We cannot assure a client that yes, you will surely win. You'll surely win. We can say that your chance of success is this. You can say, I will say that your chance of success is 70%, 30%, or 50%, or you can say that your chance of success is this. But you cannot assure the client that you will surely win. And that way, some clients may go away from you, but that will be temporary. When he goes to some other client, some other lawyer, and the lawyer assures him that yes, I'll get you the success, and ultimately doesn't get the success. That oh, my other lawyer was really correct. The other lawyer was correct. He was telling me. So we'll have to convince the client that it is not proper. No advocate can guarantee you the result. No advocate. If any advocate guarantees the result, you should not believe that advocate. I also tell all the clients that you don't believe the lawyer who says that yes, I'll surely succeed. I'll get you the success. And even if you have got a very good case, 100% case. Let us suppose you have got 100% case. Even if there is a 100% case, also you may not succeed. Also, even if so, you cannot assume that yes, I'll surely succeed the case. By this, the very difficult. So, the client is very difficult, but you'll have to anyhow show your ability to the client that yes, I'm able, because the client has come to you because you are able to. You have the capability to argue his case and conduct his case. So you'll have to show your ability to the client. Your attention should be to show the ability to the client and not bring whatever the client says. And another thing, that you must, keeping the law in mind, you must put different questions to the client, because clients tend to suppress before the lawyers also. Though it is said that one should not suppress anything before the doctor or the lawyer, but the client, I have got the experience that clients intend to suppress many important aspects before the lawyers. So you must have that cross-examining attitude, that you must put questions and find out the real truth from the client. Thereafter, even if you know the truth, you may not place it in the way he has told. You may place it in a different way. But you know what are your weaknesses. What is the weakness of your case, you must know. Thereafter, we must tell the client, yes, you have got this weakness in the case, but we'll try our best. The client should know what is the weakness in this case. Other client will say that I have given the case means I'll surely succeed. Because no client wants to lose the case. Maybe Delhi laborer, maybe Vedanta CEO, or maybe Reliance CEO, or anybody. Nobody wants to lose the case. Another experience I have got, and many experiences. Even if you succeed around, let us say, a particular client, you have succeeded around 40 or 50 cases. You have succeeded. you have fought around 50 cases for him, and you have succeeded in all the cases. In a particular case, you do not succeed for any reason. Maybe his case was weak or something like that. He will start thinking alternative. Oh, this lawyer is not doing my job properly. He will forget that I have succeeded in 50 cases. This lawyer has got me success in 50 cases, but immediately he will think of alternative. So don't treat the clients for granted. Don't treat the client. Don't take it that the client is there with me for 10 years. So he has become my family client. No, no client is permanent. All the clients are always temporary. Just mind it. All the clients are. And there is another thing. Very less sense of gratitude is there in the minds of the clients. After they succeed, very few clients remember you or that they feel obliged to you. But most of the clients, they do not feel obliged and they simply run away. Next, when they may look at you, they may not look at you, they may wish you, may not wish you. But that is a very typical experience. But you should not expect that, yes, because I have brought him success, he will remain obliged to me. That you also should not expect from him. That is that will be your foolishness. I've got a lot of experiences in that. Because I have been on the petitioner side most of the time. To opposite side, very few. But most of the time I have the petitioner side, and so I have seen all these clients from Delhi laborer to top-ranking corporate executives like Vedanta CEO or Nalco CEO, Nalco CMD, all these things. Everywhere. People say everywhere. It is very difficult. So you must not treat that the client is permanent client for me. So you must make it, keep it in mind that yes, I must do with his case so careful that he should not slip away from me. That should be the approach. You must do your duty. You see that you must make an effort that this client should not think of alternative. They should not slip away from me. That is the okay.
Indeed, sir. You have given a great example of yours and the important pointers regarding client counseling and how to handle clients. But that was quite interesting to know. Now I would like to call upon Jyoti Prakash Datta to the forum so that he will ask you the another set of questions that we have. And I would request our viewers to stay tuned with us so that you will know the answer to all the relevant questions that Jyoti Prakash will put forth to our honorable learned guest, Manoj sir. So, Jyoti Prakash, mic is all yours.
Thank you, Devasis. Thank you, sir, for answering all the questions of Devasis so lucidly and so effectively. So it was a great hearing for us, not only for me, but also for all the viewers who were viewing us during this last 1 hour. So, sir, with your permission, I will ask you some other questions in this interview. Yes, sir, as we know that you were designated as a senior advocate in the year 2011, and you have now practiced for almost 32 years or 33 years in the bar. So, sir, what are the differences between the procedure of designating senior advocates then and now?
Senior advocates, actually earlier, senior advocates are designated by the full court. When I mean all the judges, they used to pick up the lawyers and they pick up the established lawyers or brilliant lawyers and designate them senior advocates. Thereafter, they came with a rule. In a rule, there is a procedure. I'm not speaking about the present rule. I'm the earlier rule. There is a procedure, and there are some requirements to be done, and a consent letter for interaction. I mean, there's some intention that counsel has to express his intention to become a senior advocate. That also he has to give, and also he has to satisfy all the requirements, procedures. Thereafter, it is put before a committee. Committee recommends to the full court, and full court decides. That was the system then. When I was also a designated senior advocate. But later on, after Indira Jai Singh case in Supreme Court directed all the high courts to frame the rules for designated senior advocates. Basing on that, the rules were framed, and applications are invited, and all these things concept came, and thereafter the scrutiny is there. Many hurdles are there. Many hurdles are, because Supreme Court has also said that in Tom, Dick, and Harry, it is the Supreme Court version. Tom, Dick, and Harry cannot be designated as senior advocate. Senior advocate is a very onerous position which cannot be given to Tom, Dick, and Harry. Recently, also our High Court has also delivered a judgment wherein High Court had designated 5 counsels. Those were very brilliant counsels to be senior advocates by applying this Rule 6.2 of the rules, and that was challenged by other aspiring lawyers, and that was allowed. Writ application allowed. Honorable Division Bench has said that no, there should be fresh constitution. Of course, they said that the 5 senior advocates, they will not lose their senior advocate now. They will be also considered along with others at the time of final consideration. If they are successful, if they are selected, then they will return. Otherwise, they'll have to lose their senior gown. So now the procedure is virtually application form. Previously, it was not there. Virtually, it is you have to invite applications and all that. So I do not. This system should not be. Is not very good system. Why should you apply for the designated senior advocate? It is if you are the judges feel that you are eligible to become, you are fit to be senior advocate, then they should designate you on their own, of course, with your consent. Without taking our consent, they could not have done it. Anyhow, by giving all the like your income tax certificate, what cases you have argued, and all these matters after furnishing all the details, automatically you have given your consent to senior advocate. But nowadays the procedure has become something different, which is, in my opinion, it is not very good. I think the rules are very good.
Indeed, sir. You have rightly pointed out that the system that is now prevailing is somewhat deprecable, and it should not be continued. And also, our High Court
It has to be.
observed that
Supreme Court judgment, it has to be. As per the Supreme Court judgment, it has to be. So one cannot run away from this.
indeed, sir, indeed. Our High Court also said that all the persons who are applying for the senior designation should not be given this designation, because it is a position which should be allotted to only the deserving ones and only the extraordinary persons. And also, sir, after that question, I would like to ask you another question. And you have been a member of State Bar Council for more than 20 years, and you have also served as a member of the Disciplinary Committee. So,
Yes.
sir, as the member of Bar Council, which is considered as the watchdog for ethics, professional ethics, so
Yes.
what is your view on the professional ethics of the contemporary lawyers?
It is a general question. Could you be put a specific question? Ethics means all
Yes, sir.
laws are supposed to be maintaining high ethics. So this is a
Indeed.
general question.
Yes, sir.
Also,
Sir, specifically, what all decisions were taken for enhancing the professional ethics of all these lawyers during your span as member of Bar Council of
no,
Odisha?
no, actually,
And
no such decision is required. No decision is taken to enhance the ethics of the. There is no such decision is required. No such decision has ever been taken also. Because we have got a code of ethics already coded, and in that Advocates Act and the rules. So we'll have one that code is self-sufficient. That code covers all types of misconducts, and if somebody is found to be there's some allegation of misconduct, then naturally disciplinary committee is there. Disciplinary committee gives opportunity to all both the complainant and the lawyer concerned, and comes to a decision whether this lawyer is guilty of the misconduct or not. So that and that has been followed strictly. During my time also it has been followed strictly. Last 10 year only I was not there. Prior to that I was in four consecutive tenures I was there. But last 20 also they maintain it very well. They also invite senior advocate from senior counsel, in fact, not may not be designated senior advocate, senior counsels to be a co-opted member of the disciplinary committee. Co-opted member of the decision committee. They also become the co-opted members. They also become. They also guide the disciplinary committee to how to go about it and how to maintain it. But the bar council doesn't tolerate any unethical work, to my knowledge.
Indeed, sir. Sir, another thing, as Devasis asked you about importance of drafting, and he also asked about pointers and drafting. Another aspect of advocacy is pleading as well as presenting argument before the honorable court. So, being a lawyer for several decades, what is your pointers for all the juniors who are aspiring to be a lawyer one day to effectively present their argument before the court?
First of all, I will repeat that they must read, and read. Not only that particular subject, you'll have to, after you acquire sufficient knowledge, your self-confidence grows up. You feel confident that yes, I can do this. Automatically, when you are doing a particular case, read all, not only laws, also related laws also. Not only the particular. If you don't be satisfied with a particular judgment or particular decision, you read all the against judgments. First of all, that one must read the against judgments. Thereafter, read the favorable judgments, because against judgments will be cited, likely to be cited by the other side, and you'll have to answer that. And you also know where your weakness is, and you also are supposed to know that the judge also knows about the law. So if the judge knows about the law and about the when you can, judge may put a question also. Yes, oh Mr. So and so, have you read that judgment? If the judgment that judgment is against you, you have not read the judgment. How are you coming and arguing the case? So that, for arguing a case, don't be in a hurry. Read the facts, be thorough on facts. First of that is the first and foremost thing. Then second is thorough on law, both sides, against as well as favorable, and the latest decision. Because previously, what has happened? We have to give a certificate that no other this decision has not been set aside or this has not been distinguished in any other judgment. Sometimes courts ask us to give certificate. So, but if I cite a judgment, later on that judgment might have been set aside or might have been distinguished in a different manner. So certainly that judgment doesn't have any precedential value. If that doesn't have precedential value, then if the judgment is passed on basing on your citation, then you will be in difficulty. Then certainly court will have a bad impression on you that yes, sorry, I rely on this advocate. This advocate cheated me. He will say that he cheated me, put me in a false position. That because judges are not making it nowadays, judges are making their own research also. Previously, some judges are also doing some researches, but nowadays most of the judges are doing their own researches also. Besides whatever the advocates are doing, because of the benefit of this research assistants and also the computer system and all that, now they are also doing their own research. They are also, even if some judgments you have not cited, but they are citing those judgments and delivering the judgments. So this argument, you must confidence is good, but overconfidence is bad. So confidence, how confidence will be confident on your fact, confident on your law. Then only your speaking, your confidence will be more, and you will be able to argue before the court with confidence that yes, I am prepared to answer any question put by the court or the other side.
Absolutely, sir. Now, as you correctly pointed out, judges are also very much prepared because there are several research assistants who are assisting judges in research works, as well as whenever you argue in a court, our opposing counsels are very much prepared. So we have to keep in mind all these things while arguing before an honorable court. That is very much interesting to know, sir. And sir, another question that I want to ask, as you know, in the recent days, especially in the modern era, after the invention of technologies, especially moot courts are very much prevalent. And nowadays, after the imposition of lockdown, there are several virtual moot courts as well. So, do
Yes.
you think moot courts are helping the lawyers or the law students in shaping their career in a better way?
We've been virtual courts.
Sir, moot courts,
Moot
and
courts now.
yes,
No, moot courts are very helpful because moot courts give you the court atmosphere, and the moot court judges. I have also become moot court judges on many occasions. So I put also several questions to them. So by putting the moot court is very important in legal education. Very, very important. Very important. And
indeed,
one must participate in moot court competitions. All students must participate. That will help them like anything.
indeed, sir. And sir, what is your view on internships? Now, many law students are interning under several senior advocates as well as many other lawyers. So, do you think those are effective?
Yes, internships are very effective, provided the student himself or herself wants. Most of the I have also facing some some interns. They're coming after 1 hour. They're going away. They're not very serious in there. And by at the end of it, at the end of the internship, they're taking a certificate. I'm giving the certificate because that will help them in career. So, but if you're really interested, I think then it gives a lot of benefit to you because you are doing you are acquiring practical knowledge. You are reading a brief, we're reading these relevant laws, we're getting the guidance for this of the senior, not only of the senior advocate under whom we are interning, but also from the senior colleagues also. So you can have a that way that will help you in practice in future. That will help a lot. So internship is very much important, and one must do it sincerely and honestly.
Indeed, sir. That is a valuable advice, and I think all the viewers who are viewing today's, they will get some message from this advice of yours. And sir, another thing, what is the importance of judgment reading while we are still in our law schools? Because lawyers always go through the important judgments as well as recent judgments. But what is the importance of judgment reading while we are in law school? And what is the difference in the approach of judgment reading from your time to our time? Because there were no technology, SCC online or other softwares in your time, and today we have with us all these technologies. So what is the basic difference?
Basic difference is that during our time we were depending on the digest. There are different digests were coming at the being published at that. Well, no, what happened? Yes. Now,
Yes, please.
so while going through the digest, it was taking a lot of time. It was taking a lot of time. So while going through particular, we are also finding out automatically we are finding out other legal aspects also. Let us suppose I am finding Article 14 of the Constitution of India. Article 14 is a vast subject. So I want a particular judgment on a particular issue. But while reading on article, while looking at the digest on Article 14, I am finding out many judgments, many references or many judgments or many laws, many important aspects on Article 14. That are also being imprinted in my mind. And while I come to a particular decision, I feel very happy that yes, I have come out because it is just like eureka. But during these modern days, what happened? This computer system, the research work has they are doing a lot of research and very good research. Let us suppose we want a particular subject, particular type, they immediately put that and they will find a lot of citations on that. So that is really helping this young generation lawyers. But while reading a judgment, most of the lawyers, what they do, they simply read the placitum and they go to the concerned paragraphs. Sometimes placitums are also not written correctly. Sometimes placitums are also written incorrectly. For that reason, to read it, to rely on a judgment, we'll have to read the facts in detail, each and every line of the fact. Then only how that they have developed. We'll have to read the entire judgment. If it is a 500-page judgment, that is a different issue. We may skip some quotations and all that. But the facts very important. The facts you must, because each judgment is connected to the fact only. So that judgment, the ratio might be in your favor, or ultimately it might affect your case. There are a number of examples that even ratio is in your favor, but the ratio is given not in the context but out of the context. But while going to the fact of the particular case, the judgment is against you. So while citing a judgment, one must be very, very careful. One must read a judgment. While reading a judgment, one has to read the facts very thoroughly. Then only the development in which way the court has assessed the facts and has proceeded with the findings, and thereafter come to the finding of the come to the ratio. What ratio has been laid down by the, because nowadays it has become that again I said that all the students, law students, all the lawyers must read all the judgments of the Supreme Court starting from 1960 till 1990. I have not go beyond 90 till 1990. All the judgments. I mean, let us suppose I am looking for a section 55 of the Contract Act. I must look at all the judgments starting from 1960 till 1990, because from 1960 till 1970-80, law has been developed by the Supreme Court. The interpretations are being developed, and fundamental laws they have decided the fundamentals of the law during those times. Natural justice. Now natural justice has been enhanced like anything. But how natural justice came into force, that is from 1964 Supreme Court till now. At that point of time, what is the principle natural justice? Principle natural justice is not treated in the law book. Many things are not written in the law books. But you'll have to find out the laws. It is the judge-made laws. These are all. These are judgment laws. Judgment laws are also, and nowadays what is, let us say today is a constitution bench judgment, 5-judge judgment of Supreme Court. After 10 years, another set of 7 judges, they said no, that judgment is no longer a good law. So judgments are always volatile. So judgments, no complete judgments are not coming. So judgment research based on judgments is not good. You'll have to make yourself thorough on the fundamentals of the law. All this, whatever law you are dealing with, either practicing or studying, you must go to the basic fundamental of that provision. Let us suppose CPC fundamental. You must read that provision again and again. You might be after reading 10 times, you might have left anything. Let us suppose you are filing amendment application, Order 6 Rule 17 CPC. You might have read again and again. Order 6 Rule 17, you can become confident and fine. But sometimes you might have left something you must not have. So you must imbibe the language stated in the statute. That is the most important. Thereafter, go to the law, how it has been developed. And when you are citing a judgment, you must the first initial judgment. What is the judgment? Thereafter, gradually go through the subsequent developments, so that your knowledge will be sharpened and you will be very much thorough on the subject. And all that, once you read all these things, you then do not read for the second time, because it will be kept in your mind. And of course, always you are supposed to keep a notebook with you. Khata with you, where you can note down all the important judgments that will help you in future.
Indeed, sir, very good advices are provided by you. One thing that I must highlight, you said there must be some judgments which are whose ratio are in our favor, but the conclusion is not in our favor. So we have to study the judgment in its entirety. We have to know.
Sometimes you rely on the judgment cited by the other side. Sometimes you rely on the judgment cited by the other side in our favor.
Yes,
most of the time, I have also done it.
Indeed, sir. Yes, sir.
The placitum is very bad. Don't look at the placitum. Forget that there is a placitum. Read
Indeed,
placitum,
sir.
then boys and girls, they go to the state paragraph 55, like this. Like this. Then forget about what is the fact and all that. If you put a question, what is the fact of the case? Sir, I do not know. I have not read it. This is that will sharpen your knowledge. Because to become a good lawyer, two things are very important. What I always say that intelligence and knowledge. Intelligence can be developed. Even average person can grow intelligence in course of time, and knowledge also can be grown. You will have to acquire knowledge. The more you read, you acquire knowledge with devotion. If you read a particular thing with devotion, automatically that will be embedded in your mind. So automatically you will be able to grasp it. If you are not with keeping your mind somewhere else, if you read, you will not be able to grasp anything. So Vidya and Buddhi. Vidya is knowledge and Buddhi is your intelligence. So mixing together, you become great lawyer. The knowledgeable persons do not become a great lawyer or good lawyers. Even the intelligent persons without any knowledge also do not become a great lawyer. They become a fatata. Other languages they use. I do not want to say all these languages. But the thing is, they do not carry a good impression in mind of the judges and also in minds of your lawyer friends. You must command respect amongst your lawyer friends as well as before the judges. Judge must also respect. Even if you are a young lawyer, if you are prepared well, judge also respects you. Judge also has a good. Judge also carries a good impression on yes, this boy or girl has read well and is thorough on the subject. So that way, discussion always goes in favor of that boy or girl or any lawyer. Any lawyer. That way, that is very important. And we must devotion is most important. Unfortunately, nowadays the students are not coming to practice. NLU or any other, they are not coming to practice. They are going to corporate jobs. But that's unfortunate. If they come to practice, they will easily they'll earn much more money what they are getting even at the initial stage. Maybe after 5 years, 10 years, or 15 years, they will get earned, but they will be duly compensated. But unfortunately, they are not believing that. They say that they are losing patience. Patience is very much important aspect in becoming a lawyer. Patience very much important.
Absolutely, sir. You very well pointed out that we have to be patient and we have to go through the entire judgment. We have to know the facts. We have to, in a devoted manner, we have to know all the things. And especially, we have to know the facts because it is always said that a lawyer should be a master of the facts. And without knowing the facts, we should not apply the law because that will be hazardous. Indeed, sir.
Right.
And sir, the next question that I want to ask you is something about morality. If you will be assigned a case and which is against your moral, and you think that if you conduct that particular case, it will be confronted with your morality and ethics, what would be your approach to that particular case?
It's a very tricky question. But again, I'll go to the professional ethics. Our ethics doesn't permit us to deny a case. Our professional ethics doesn't deny us. And you must not assume that this person is guilty or not guilty. You have to, after going to the, there are so many cases they are convicted for rape or murder or dacoity, but in High Court or Supreme Court they are acquitted. They are acquitted. Why they are acquitted? Because the evidence are not sufficient or prosecution was not able to prove it. So my impression is that morality is a different. We should not go by this what you say that the press said that once a particular case comes, people think that yes, he is guilty. Before the press treats as a guilty, people think that yes, he is guilty. But ultimately, when he is acquitted, but he is guilty in the minds of the society, his friends, relations, and the other areas of life in his professional career and all that. So that is the reason why the morality is an important aspect. But the thing is that when a brief comes to the lawyer, he must see what are the materials before him, what is the evidence before him, and how he can argue the case. Then he has to, even if with the very same evidence, the trial court has convicted, but High Court is acquitting or Supreme Court is acquitting. So you cannot say that you cannot deny a case on the ground of this. This question is not applicable to the lawyers at all. This is the press-related question. The common man put a question like that. But the lawyers cannot put that question. Common man can put a question. Oh, you are defending a rapist, you are defending a murderer, you are defending a such and such a dacoit. You are not defending a dacoit. Now you are saying that he is a dacoit. He might not be a rapist, might not be a dacoit, might not be a murderer. Ultimately, there are many cases. I have argued many criminal cases, criminal appeals, and most of the cases I have got them success and said that yes, they have been acquitted in the rape cases, from the murder cases, and ultimately, what moral? Let us come to a rape case. Rape case, two aspects: with consent, without consent. With consent, no rape. Without consent, rape. If it is he sees agent above 16 or 18. So what happens? So it's a matter of evidence, consent or no consent. So matter of evidence, if you can prove from the evidence that yes, she had the consent, then naturally she will be the person will be acquitted. So how is the morality? I will say that they rapist, so I should not do the case. So that should not be the approach of the lawyer. In that case, no person will be able to get any justice, even if he has done it. Ultimately, if he has done the offense, ultimately the Supreme Court he will be punished, and he will be let us say the way these 4 persons were hanged in that case, that rape case, that famous that bus rape case. The 4 persons ultimately they are hanged, but it is your duty to represent your client before the court.
Absolutely, sir. The first morality that a lawyer should profess is to uh, bind himself with the professional morality. And
Yes.
you have, yes, sir, you have very aptly pointed out, sir. Indeed, sir. And sir, another thing, whether a junior lawyer who is going to join the bar or who has just joined the bar should have any specialization in a particular subject, or he should accept all kind of briefs, whatever he gets.
My advice would be to accept all kinds of this, because normally when you, as a senior counsel, senior advocate, the lawyers come with different varieties of cases. Varieties of cases. All the senior advocates will find they to conduct all types of cases in Supreme Court, in High Courts, all types of cases, criminal, civil, all kinds of cases. Not that they are limited to taxation, anything. So he must, if he has the scope to learn and get the brief in different subjects, then he must do it. Specialization, I don't think specialization will be, because specialization it is better to be specialized in a particular subject, but if you have the scope to get other kinds of briefs, then you must get it, and you must do it. That will help you, that will sharpen your ear, that will also enhance your professional image also.
Indeed, sir. You have aptly pointed out that we have to accept all kind of briefs, and it will help us in growing our practice as well.
I have been doing that. I have been doing all kinds of. My chamber is full of different varieties of briefs. Varieties of briefs, all kinds of briefs, except some income tax and sale tax matter. All kinds of briefs are there in my chamber. That is the reason why most of the students also come for internship to my chamber. Also, because they say that you can, if they want, let us suppose go to commercial law, civil law, criminal law, any kind of law you find out. Any kind of brief my chamber has got. That is the advantage I have got. Therefore, I always propose that one must look at all types of briefs, if it is possible, if it is available to him.
That is interesting to know, sir. Must be your interns must have been very much benefited from your various kind of briefs. And after that, sir, you have been practicing law for decades now, and you have dealt with many such matters. So, do you feel there is any provision of law which are being misused nowadays? Like we have seen many frivolous petitions are filed in the Supreme Court as well as in High Courts. Do you feel there are several other laws which are being misused nowadays?
First, I'll say these PILs. PILs have become private interest, personal interest litigations. Personal interest litigations. And regarding the particular provisions or particular law, we cannot say. Nowadays, sedition laws are also, sometimes sedition laws are also not being applied properly. But the Supreme Court has been, High Courts and Supreme Court have been dealing with the sedition laws. And sedition law is a very serious law which should be applied sparingly, not casually, at the whim and caprice of the ruling government or any particular sedition law. That is a particular, most misutilized provision law now. But I can say about the specifically other laws, but specifically sedition laws. But not that sedition law is not used by sedition law. Now that demanding to removal of sedition law. The sedition law should not be removed because that is a very serious law, and one cannot be whacked. One cannot commit an offense like this. But the way they are being treated by the different governments or different prosecuting agencies, that should be limited, or that should not be misutilized. Utilized properly, not misutilized. And PILs, most of the PILs have become now. Some PILs are genuine PILs, but very few. Hardly 10 to 20% PILs are genuine PILs. All other PILs are personal interest litigations, either to advertise his own name, or to blackmail somebody, or to anything we can say. The PILs, most of the PILs, but some PILs are really good by the genuine PILs.
Absolutely, sir. There are several genuine fails, and at the same time, we have got several other personal interest litigation or publicity litigations. So this should be avoided. Very aptly pointed out, sir. And sir, another thing that is one of the most important things in lawyering is the relation of the bar with the bench. And the bar and bench are treated as the two wheels of the same chariot. So, do you think, sir, there is a friction between bar and bench nowadays in comparison to what it used to be in your times when you started your practice?
No, I will not say that, because during our time also, of course, the judges are maintaining excellent relationship. Because there are now we are missing weeds from the court. It's all serious business. Previously, in our young days and even our middle age, middle stages also, the judges, they used to cut jokes. They used to have witty replies. The lawyers used to have witty replies, and judges were not misunderstanding it. Like this, some things were going on. Like this, one particular example, I'll say, 1983 or 84. I was arguing a criminal division before Dr. Justice B.N. Mishra. That was related to section 145 custodial ages. But that was around around 4 o'clock. So instead of, by mistake, I said instead of custodial ladies, I told custodial ladies. So Dr. B.N. Mishra is a very, very witty man. But he said that, oh, Mr. Mishra, you are a young man, not married, so you must think about ladies. So, but it is mine. I am an old man. It is my tea time now. So I am rising for tea. You think about your ladies. So that was the bit. Even judges were used to cut jokes with the young lawyers also. And so I was a little bit embarrassed. Don't get embarrassed. Don't get embarrassed. I was just out of joke I told. So it was just a slip of tongue. Custodial ladies, and I said custodial ladies. So in which manner he put it? In a very joking manner, said that you think about your ladies, I am thinking about my tea. Just like now, recently you must have had Justice Chandrachud say that, oh, 4 o'clock, I must go and have my tea. So nowadays judges have become very serious, and this wit aspect is missing in the present day judges. Otherwise, the relationship between bar and bench is still very good, and most of all our judges are really excellent, and they're very good, and they're very cooperative to the bar. Everybody. All the judges are very cooperative with the bar, and we have got a very relationship. You can say a very close relationship. Yeah. So that is even then, but in Supreme Court, I find sometimes there are some difficulties. But in our High Court, that is not.
And it's nice to know about that. And I think we will be missing that particular aspect of wit. We have been reading all those things and during our law school days. We have been reading all those things that the court conversations used to be very much witty, and the lawyers used.
One wit department, Justice G.K. Mishra, the famous Chief Justice. Though he was for 6 years, he was Chief Justice of our High Court, but he was not elevated to the Supreme Court, unfortunately. But he was a highly talented judge. And Mr. Ashok Das, former Advocate General, was a very witty man and he was senior of my senior, Dr. Bipin Veratha. So he used to come 5 minutes, 3 minutes, 5 minutes late. Before lunch, he was arguing matter. Before lunch, the court rose for there was a rose for lunch. After he assembled, Mr. Das had not come. Mr. Das was arguing that matter. Mr. Das' house was just in front of the High Court, about 300 meters from the High Court. So after judges were waiting, Justice G.K. Mishra was very angry. How Mr. Das is, doesn't have the sense of time and all that. We are sitting on time. At that point of time, judges were sitting exactly on time. Most of the judges. Time he is not coming. After 5 minutes, he came in a very clear, very slowly, very relaxed way. And we are sitting in the court. I was very young counsel then. So that Mr. Das, don't have the timing sense and all that. How we not expected of you. Plus, my Lord Justice, understand one thing. This is the only time I can relax. But I can relax. This is the time my children are at school. My servants, after giving them, they are at the ground floor, they are in their rooms. So I am left with my wife. So if there is some 2-3 minutes delay, Lordship may understand it and must condone that delay. But not only judges, all the lawyers laughed. That was the situation then. All the judges laughed, all the judges and the lawyers laughed and laughed. That might not be a fact, but to have a witty answer, he very nice way he put it. And the other side laughed and they continued hearing. So these things are missing nowadays. Last we had witty judge was Justice Parija, Suras Parija. If you go to his court, he'll forget all your worries. Even if you do not succeed in the case, if he decides against you, he will come out of the court laughing. He was such type of witty judge, full of wits. I told him he is a close friend of mine. He's a closer friend of mine. So I always took him nickname is Tukulu. Tukulu, after your retirement, we'll have to forget the witty part in our High Court. Then asked me tell the president to extend my service. That also he answered me. Extend my service till my death. I'll be there. I'll make you laugh all the time. Just make a representation and make me judge till my like American system. Make me judge till I die. That also he replied in a very witty manner.
Indeed, sir. We had the fortune to attend some of the proceedings of Justice S.C. Parija, and you are very much right. He is very witty man, and we hope that all this wit part will be restored in the coming days. It should not remain absent because it is the one thing which relaxes the council amongst all these busy hearings.
Judges also.
Indeed, sir. Indeed. And sir, another thing that I want to ask you is about the legal education system. As we know, nowadays there are several national law universities and several top private law universities as well. So the quality of education must have increased. But in the state universities, especially, we can say in Madhusudan Law College or our University Law College, in these colleges there are some kind of faculty problems, and In the older days, we have come to know that many senior advocates used to visit as visiting professor. Nowadays, that is missing. So, do you think senior advocates should visit law schools for giving lectures?
Yes. But nowadays the law universities are not inviting them. Not inviting them, but they should invite them, and they must go. And not only that, the difference, as you say, faculty problem is there in the national universities also. And nowadays, students are basically educating themselves. What I have learned from the students themselves. The students are my students are coming for internship. Students are my own relations or some known students are there. So they say that the faculty problem is there everywhere. Even in Bangalore also there is a faculty problem. Faculty problem is there always, And basically, what the law, whatever you just, study in law college, yes, that is good. But when you come to practice, you'll have to read it again and again because that is practical knowledge. As in Odia, we say Puthi Baigan and Badi Baigan. The garden brinjal and your book brinjal. In book, you can have very good brinjal, but in the garden to cultivate a brinjal, very difficult. So when you come to practice, you'll have to read it again with different perspective. There you are reading for the purpose of exam, but here you have to read for the purpose of case, for fighting a case. So for that reason, you'll have to read it again with reference to the decisions, with reference to the facts, with reference to different aspects. So whatever is read in law colleges, that is not important. I said that not very important. So far as practice is concerned. For others, that may be very important. But nowadays, what has happened because of this computer age and all that, people are getting themselves, students are getting themselves educated. They are educated. Very few teachers are there who are able to educate them properly. Because they must also go to that level. The students are much above the level of the teachers nowadays. Because of this computer system and all that, the intelligence of the students. Nowadays, present day students are highly intelligent. And especially MS Law College, as you say, even let us suppose my son Tanmay was also reading in National Law College. He has not gone to any national law school and all that. He did a 5-year law course and thereafter he joined practice. And I'm told that he's doing very well. I'm told because I have not never had his argument. But even judges are saying or the other lawyers are saying that yes, Tanmay is doing very well. How? Because he had to read again in the chamber, and again he had to read the briefs and with reference to the briefs and with laws, separate laws, decisions, he had to prepare them the case. That is the reason why, even if he has read it in the law college or not, I do not know. But even if he has not read in the law college, doesn't matter. He can read it here in practice. One can easily acquire knowledge because it's very easy to acquire knowledge. I say very easy to acquire knowledge. Very difficult to forget it. If you acquire knowledge, then it will be difficult to forget it. It will be there in your mind, memory till last.
Absolutely, sir. As you have said that the knowledge that we acquire in the law college is something different from what we acquire in the bar, and
But
many
in
legends
law
also say.
colleges, they teach the fundamentals. In our time, they were teaching the fundamentals. So our education was very much important. And during our time, there was no copy. During our time, because there was a emergency time, so we had to read and read and pass. We are not. There is no copy during our time. From 75 to till 77, there was no copy.
Indeed,
Nowadays,
sir.
also, copy system is now not there. Nowadays, there is no copy system. I'm told.
Yes, sir. There is no such system prevailing now. And sir, apart from that, we are fortunate to go through your curriculum vitae, and you have mentioned that you have visited more than 75 countries, and in relation to your professional works as well. So, sir, as you have visited so many countries, and especially we would like to highlight the professional aspects of those visits. So what are the memories and what is the anecdotes about all those visits, sir? Can you share with us some?
Most of the visits are my person, because I have got very passionate about traveling. I'm passionate about my profession as well as traveling also. So passionate about traveling. So every vacation used to go out prior to Corona. With 2-3 friends, we go out to different countries throughout the world. Uh, so professional connection, only 2-3 occasions I have gone in international arbitration. Only 2-3 occasions I have gone to, not much, only 2-3 occasions. Once I had been to South Africa to attend a conference, world conference, when my client, that is at that point of time, Miller, this famous beer company. Now it is Budweiser has taken over. Beer company. They had got the head office at South Africa in the that famous place. What's the name? I just forget the name. Near the sea, on the sea, that city, where the your water scarcity, though it is on the sea, but water scarcity was there. Cape Town, Cape Town. So they had
Cape Town.
the conference at the, so their lawyers throughout the world had gathered. That was a very good experience. Throughout the world they had gathered. So I was from Orissa, I'm from different, from India. 5 lawyers we had gone there, and throughout they had a conference of all the lawyers in that Cape Town. That was a different area. But in other arbitration, you go for arbitration and come back. That is it. No such anecdote or no such specific experience. But you'll have to be very, very thorough on the subject while appearing for the international arbitrators and all that. Only 3 occasions have, two occasions have gone for international arbitration, 1 occasion I have gone for this. But rest of the time I have gone for my own as a tourist.
Sir, have you visited any courts of foreign jurisdiction?
Yes, I have. Once I had gone in London itself. The trial was going on. There I found that all judges were, there was a friendly atmosphere. Judge was sitting, and the trial court and the client was sitting. I mean, the accused was sitting, lawyers were sitting, and all that. By sitting, they are arguing and all that. By sitting, they are arguing. That is very specific argument and all. So and all that. Very few persons are there in the court, and very effective interactions were there, and all are friendly. Not that judges were sitting and advocates are standing and all that. Everyone. So that only one instance I have got. Otherwise, I do not have any other instance. Because to go to court, you have to seek the permission. At that particular day, anyhow, we requested a particular day, then he arranged a pass for us in the London court, and that is not very. They're not very strict about it. So I could be able to attend that London trial. But, other day, you'll have to need a pass. So without pass, how can you get a pass? As a tourist, it's very difficult to get a pass. It's a very secure place. Nowadays, also our high courts, all the high courts and Supreme Court also, you cannot enter into as a tourist. You cannot enter into. You'll have to show that you have got a case and all that.
Yes, sir. Interesting to know. And we require pass, and there are several security concerns. Probably because of that, they're requiring pass to give the entrance. Sir, one thing more. Uh, it is something unconventional, and we often ask this to our guests. As if you will be given a chance to go back to your law college and to read the law again, do you have anything that you couldn't do while you were a student, and if you will be given another chance to do, you will do that again?
If I am given a chance, I'll stick to reading. I'll stick to reading because by not reading in colleges, I have faced the difficulties. So I'll stick to reading, not go out anywhere for chai khatti and all that. I'll not go for chai khatti and all that. I'll stick to reading. I'll carefully listen to the lectures. I'll go through the books and I'll carefully attend all the classes. That will be my. I will not go for. Maybe occasionally we may go for psychiatry after the classes are over, not before that. I cannot think of missing the classes as I was doing in my college days.
Yes, sir. And especially we ask this question so that the senior members of the bar would give some insights, and that will be helpful to all the junior members who are viewing us. So it is a very good advice that we
I
have
have
to
faced lot of
reflect.
difficulties. I have faced a lot of difficulties by not reading only for the purpose of passing examination. Only I have read, but not reading not attending the classes regularly. I face the difficulty in practice. That is the so that is the reason I heard that if I given a chance, then I'll go and simply attend the classes and listen to the lectures carefully and follow the lectures.
Indeed, sir. I think all the viewers will get a message from this. They have to attend the classes regularly and sincerely so that they will be thorough with their subjects, and those lectures are also valuable because we are taught by several trained personalities and we should utilize that opportunity. So, sir, the last question of this talk show will be what will be your advice to all the junior members of the bar or the ones who are in their law colleges but want to join litigation? And especially, what will be your advice to all those persons who don't have any backing in this legal profession, who are first generation lawyers?
I am the right example. I didn't have the backing. From the beginning, I told that I had to run to a particular person 6 months to get a senior. I have no senior was prepared to accept me. So fortunately, my brother-in-law, one of my cousin sister's husband, he had some attendance with some judicial officer. Through him, I could be able to go to Mr. Vibhuti Bhushan Rat's office. So if that is my case, so why not? So what is the? It's not necessary to go to have a legal background. It's absolutely not necessary. Most of the successful lawyers here, they didn't have a legal background. They didn't have a house also. I had a house in Cuttack, but they didn't have a house also Cuttack. But they have constructed huge buildings, and most of the lawyers, they didn't have legal background at all. Most of the successful lawyers are not about the very top rank, mid level lawyers also. They didn't have the top level lawyers, mid level lawyers. It's not necessary to have a that is the very, very peculiar wrong notion in the minds of these that I must have a legal background. Legal background is not necessary. You'll have to make yourself available, and you'll have to prove yourself that yes, you can be a name. You can be a name. That is it. Since that is my personal experience, and most of my friends also. They didn't have any house also, but they have now constructed not only one but 2-3 houses, and they are now very senior. I can take the example of Mr. Buddhadev Raut, one of my close friends. He was he didn't have a house at Cuttack, though his village is nearby, but he didn't have a house at Cuttack. But he was attached to Mr. Ramakant Mahapatra's office. And thereafter he came to he established himself, rose to a top level advocate, to senior advocate, top level senior advocate. And so it's not necessary. He is my travel partner also. He used to go to foreign countries himself. Mr. Jagabandhu Sahu, our Bar Association president, he didn't have any legal background. He didn't have legal background. He didn't have any house, or he didn't have any legal background. He not even his totally raw village he had come, and now you see his position. Now you see his position. So, but there's the examples. I'm telling you 2 examples only, but there are a number of examples are there. I can give number of examples, but I don't have to give number of examples. But 2 examples are there. Now he is the president of our High Court. Also, not only president, but he noted so far as taxation law is concerned, he is the topmost lawyer in taxation lawyer in our High Court. So how he established himself? He didn't have any legal background.
Indeed, sir. Those two examples are more than enough to pass the message that it is not compulsory that we should have a legal background. With our honesty and with our sincerity, we can do whatever we want to do in this profession. So, sir, it is the end of this session. I must thank you for giving so much of time, almost 2 hours you have spared for us to talk with us and to accept all our questions. It was an honor, sir. And before parting with this show, I will request our co-founder Devashish Kumar Panda to come on the screen and to give a formal vote of thanks.
Before that, I must convey my thanks for inviting me and giving you an opportunity to speak in this on this forum.
It's our honor, sir. We are highly grateful for that. Devashish, please.
Yes. Thank you, Jyoti Prakash, for calling me up, for giving formal vote of thanks, and also thank you for asking all the relevant questions, and thank you, sir, for answering them so lucidly, which will be helpful to our viewers and whoever views this video in future. Now, as we have come to the end of this particular interview session, I would like to give my heartfelt thanks on behalf of my team and Jyoti Prakash Datta to our honorable guest, learned Manoj Kumar Mishra, sir. We are really privileged to have you today's evening, and we are highly grateful, sir. Thank you so much, sir, for sparing almost 2 hours of your valuable time from your busy schedule. We are really, really obliged and humbled. We are really privileged. So thank you so much, sir, for coming to this particular interview and having with us on board. Thank you, sir.
Thank you. Thank you.
Grateful, sir.